built during the process. So he has to maintain throughout the process. Now fourth part philosophy. How much will the ant gather during the summer to prepare for the winter? All that possibly can. So what can a mediator do in the mediation? The mediator can help the parties he can reassure the parties that don't give up. There is still something you can think about. Have you thought on the other things? Because mediator is one who facilitates. Mediator is not a judge. He is not going to suggest. You know very well that mediator cannot advise. Even if the parties ask what is your advice, he cannot give legal advice. He cannot suggest. Then what is the role of a mediator then? He is just a facilitator. He is a torch bearer. He is going to throw light into the dispute and help the parties to arrive at a mutually acceptable resolution. Do all you can and more. See, despite the mediator doing the process, if the parties do not arrive at a mutually acceptable solution, doesn't matter. But the process should never be compromised at any stage. You are just doing your role. You finish your role, do it properly. Doesn't matter whether the parties accept the solution or not, but your role is 100% done. You should be satisfied with what you are doing. The confidence of the mediator should be given to the parties, because parties have totally they are in distress. Just like a patient going to a doctor, he gives up. He totally surrenders to the doctor that whatever you do, doctor, you have to relieve me from the pain. That's the confidence the patient has in a doctor. Similarly, the parties who come to the mediation center reposes faith in the mediator, and mediator has to try his best. Why the 40-hour program is given to the mediators? To equip himself or herself so that whenever you are in charge, you are in the driver's seat. See, without skills, you cannot move forward. Why 40 hours training is essential is you learn all the skills during the 40-hour training program, which will be useful during the process of mediation. For example, when the parties come to a mediation center, you are doing if suppose the ground rules, for example, ground rules are not explained, that when the one party is talking, the other party has to listen, and your mobiles should be switched off, though no recording here, and though this is not a court, you have to maintain the decorum of the court, and so many other ground rules. That is, whatever happens here is not going to go to the court, but though the reference is mandatory, the process is mandatory, but the participation is voluntary. You make the parties sit in front of the mediator, and next to them is the advocates. The role of the advocates is also explained during the opening statement. Once they come to know that this is something different, because the first time when they are coming to the mediation, it's a different atmosphere. So the mediator has to be with a cheerful demeanor. He introduces himself, and even if it is a 13B petition, I request my learned mediator friends that you have to do the opening statement. Even though the parties say that there is nothing to be done, we have already settled and all that, but despite that, please explain them the process. And normally in my experience and in the experience of my learned other mediators, normally the opening statement should not spread too long or too small also. It is for at least 5 minutes should be sufficient. We should not blow our trumpet. It is just to give a background that you have had so many years of experience and you are in the field, and nothing more than that. This is here to help the parties. It is not just to self-proclaim or something about the mediator. Mediator, he is here to assist the parties to arrive at a resolution. Then once the opening statement is effectively done, then it is in the joint. Why is the joint session done? There also you may get hurdles. If the opening statement is not done, what will happen? Now let's have the interaction. Ma'am, Vaishali ma'am, in your experience, if effective opening statement is not done, what would happen eventually? Will it be a successful mediation, or are we going to have an obstacle in the beginning itself?
It's an obstacle in the beginning itself because the parties are not involved in the process because they do not know what to expect.
Okay.
And they do not know the various probabilities and possibilities until an opening statement is done, and thereafter it's proceeded.
So suppose an effective opening statement with all the ground rules is explained. Is there any possibility of any hurdle in the opening statement?
It could be, but that is depends on the mediator's
And who has to control the process? Suppose there is going to be some violence or something while the joint session is in progress.
Always the mediator.
So always let us understand, it is for the better understanding of the new mediators. I am explaining the process because mediation, that is 50% you are already on the negotiation if a proper opening statement is done. Do you have any difference in that?
None at all.
So it should be in the language which could be understood by the parties. Suppose the parties are come from the rural place, or when we go to a district to do the training, we have to do in the language which they can understand. So it is from the parties' perspective that a mediator has to understand. It is not the mediator who can just go on doing in his own way without seeing the party's perspective. The mediator has to step into the shoes of the parties. Then only the mediation process can be successful. Then let me ask Mr. Joe, who has been a very close trainer and this thing. When a joint session is going on, do you think that there can be any hurdles if the mediator is not vigilant or he is not watching, observing? Do you think anything can happen in the joint session?
Yeah, it's always possible there can be obstacles coming up when joint session is happening. If the mediator is not ready to control the emotions, the aggressiveness of the parties, all this has to be watched by the mediator, take control of that. Otherwise, there can be obstructions.
There can be obstruction. Thank you, Mr. Joe. And any others who have any differ this thing? If the proper joint session is not controlled properly at the right time, if there is a direct confrontation going between the both parties, if they start directly, what should a mediator do? When a direct, see, let us have interaction because it is not one-sided. I am not here to teaching, we are sharing the thoughts. In my opinion, if the joint session there is a turmoil or there is a direct confrontation between the parties, it is better we go for a private session. We have to split the joint session and go for a private session so that we can take the control of the process. Never allow the violence to continue because then there will be a serious violence which may also affect into physical abuse also. So a mediator is there who is in charge of the process. It's just like a driver's seat. A mediator is sitting in the driver's seat. So he has all the tools. He has to shift the gears. He has to work out which is the speed he has to take, go forward. So entire thing is in the control of the mediator during the joint session, and if it is not controlled, then we may have a direct obstruction in the joint session. Then after moving forward, then we have to go to the private session where we can understand the nuances and the what exactly we can identify the issues when going to the private session, the strength and weaknesses of each party, and only in the private session with the help of the advocates also we can look into the by our mediation skills what we call as Bhatna Vatna is applied, best alternative to a negotiated agreement, worst alternative to a negotiated agreement, and even the legal technical issues, whether it is barred by limitation, whether this thing, if it goes back to the court, what will be the worst thing which can happen, and if it is resolved in the mediation, what is the best thing which can happen. All these things, pros and cons, will be discussed in detail in the private session, because they don't want to disclose before in the joint session, because they don't want to reveal what are the strengths or weaknesses. Let me come to one matter which I had handled because different cases we would have had experience. I would like to share one experience with you. It was a very tough case. It was a commercial matter which came some time back, and it was regarding the digging of the tunnel. Digging of a tunnel where a mediator, I being a law person, I don't know anything about the technicality, but with an open-mindedness, I could understand with the help of a technical person who was there with me. He showed me all this thing, that is with a diagram on his laptop. He had come prepared, and they showed me that this is the diameter which they had to dig, whoever the contractor which had taken this thing, and they have deliberately done the excess so that they can get more labor, and it was with a malified intention they had to do, and it was not done in accordance with the whatever specifications we had given them. So thereby there was a loss, huge loss, and they also abruptly left, and because the payments were not given, which they exorbitantly demanded, whatever was agreed in the agreement was given. Nevertheless, but they had demanded illegal demands or for whatever extra done, that could not be fulfilled. So the matter went to the court. They had filed a suit for 10 crores and it had come for mediation. The opposite party, also being a very reputed company, had made a counterclaim of 10 crores against them because they had to hire some other contractors and get the job finished. So this, while doing so, I understood in the private session that there were some technical issues also and legal lacunas. In case it goes to the court, what would happen? I discussed this. Though after 2 or 3 sessions, they wanted to go back to court. But when I had a private session, one separately only with the parties once, and what will happen to the reputation, and they may lose their further contracts, and all these strengths and weaknesses when they were discussed, and they were satisfied. They thought I had put the thoughts for them to ponder upon that what will happen to the reputation. They may not get, and they'll be blacklisted. So when this was made aware to them, they immediately realized that I think we should sit down and resolve it. Though they initially had wanted to go back, they came back, and I had also sat down with both the advocates separately. All the band of advocates had come, and I also discussed some legal strength and weaknesses with them. In case it was already 10-year-old, a decade which was lying in the court. It had come for evidence stage, and at that evidence stage it had come here. And this thing in mediation, they agreed. Then they agreed that they will withdraw the case, and the other side also said that we will also withdraw our counterclaim. It was set off, and the success of mediation took place. They shook hands, and they said that we will also we will maintain the relationship and look forward to give some more orders to them. See, here in mediation, not only is the dispute being resolved, but the parties are also restoring the relationship. Similarly, even in husband and wife, and parents and children, they all come to the mediation. So, what we learn from this is anything is possible in mediation. There is nothing like dead end. A mediator also always has to see there is a bend at the dead end. You should not give up. So this is the motivation. Next topic. So we saw the ant philosophy here, where a mediator has to be focused. He should not give up. And though the process is sometimes very tough, it may be a hill terrain where you are climbing a steep hill. Hairpin bends are there when you are driving a car. and I going with, I have seen, gone with a long drive to Gulbarga with Mr. My good friend Sri Kumar for a training program. His focus was so good that we have to reach there and do the training, and no stops in between. We were so disciplined that because we had to go on for 10 hours. So that was the focus which I learned from a learned friend. With every trainer, wherever I have gone, I have seen that I have learned something positive. With Anuradha ma'am, I had gone for a training and I learned so many things from her in the training. I have gone with so many our mentors, Joe Joseph, it may be Kiran. Every time, because we were open-minded to learn something from each other. See, this is where learning never ends. What I am trying to say is, a mediator should always be open-minded. He should gather something good from each other, sharing of thoughts. When we go on training programs, we learn all these things so that our knowledge enhances. I can pick up some more specialized skills. When we had, when I had gone abroad, when during the program, training program, I could not take a training which I was supposed to take. It was mandatory. When I came back, I was very much disappointed that my name was removed from the trainer. So Mr. Chandrasekhar Reddy here happened to be the director at that time, and I requested him, sir, I feel I have lost something in my life. I am very frustrated. I don't feel like coming here. Can you do something about it? ನೋಡೋಣ ಮೇಹ್ತಾ ಅವರೇ, ಏನನ್ನ ಮಾಡೋಣ, ಯೋಚನೆ ಮಾಡಬೇಡಿ, ಬೇರೆ ಕಡೆ ಎಲ್ಲನ ಟ್ರೈನಿಂಗ್ ಆದರೆ ನಾನು ನಿಮಗೆಲ್ಲನ ಕಳ್ಸಕ್ಕೆ ನೋಡ್ತೀನಿ. These are the reassurance he gave me, and I used to remind him every now and then. And once a Delhi training program had opened for that particular thing, and he said, are you willing to go there and do your training program? You have to pay from your own pocket because you had missed here. We cannot, our institute cannot afford to pay. I said, readily I can go, but I want to get back to my trainer role. So there I did the training program and I got back as a trainer. That gave so much a satisfaction that I continued doing the training program. See, when you have something, you are passionate about something, you will definitely do it. You will not see the hurdles. Though there was a hurdle, and that did not prevent me, because my focus was to get back as a trainer, because I was enjoying that role. And whatever we enjoy doing it, we do it wholeheartedly. So also, my friends, when we are passionate about mediation, the process should not matter at all. You do the right thing, you try to do whatever you can. During the process, there will be ups and downs, there will be venting out of emotions, and so many things happening. But never give up. That should be the motto of every mediator, not to give up and go on till whatever the process. Whether it settles or not, it is not in my control. The outcome is always in the hands of the parties, but the process is within my control. So my endeavor and my appeal to all my mediator friends who have joined recently is, whatever may be when you are doing the process, never give up. And if suppose you are not able to understand some of the technical issues or something, you can always look back on the senior mediators or take their assistance or guidance. They will always be more than willing to help the mediators who have joined. So that is what you should remember. Now, role of a mediation in conflict resolution. Now, this is the thing which I had prepared. Now, there will be unresolved differences leading to disagreements. There will be disagreement. This is what we call during the negotiation process. When we are going with the negotiation and communication skills, that time we will confront these things where differences will lead to how the conflict is going to escalate. I am going to how it starts. First, unresolved differences. There will be a slight difference between two persons, that will escalate into disagreements. When it is further escalated, disagreements cause problems. If the problems are not addressed, then they become a dispute. And when a dispute left without resolving it, they become conflicts. So dispute manifests itself and become a conflict. What we see in the courts normally, we see the conflicts or dispute in the courts. Dispute. Thank you, ma'am. So I got confused for a while. However, so what we see in the court is only a dispute. That is 10% visible. It is just like an iceberg. When we see an iceberg, 10% is the only thing which is visible to the naked eye. The 90% which is below the water, that is what is called as conflict. So the courts never address the conflict. It is only the mediators, before the mediators, the parties, when the court refers a matter, they come before the mediator, they start talking what has happened. When we start asking them the right type of questions, we have been asked to ask, when we had 40 hours training program, we were given an exercise to talk to each other for 5 minutes. You remember? During our training program, why was it done? What was the purpose of this exercise? It was to understand each other. One has to talk 5 minutes to the other person, and he will, without talking or interruption, he has to sit down quietly, and it will be vice versa. And the other person talks to the whatever topic it may be taken, and in those 5 minutes, we used to grasp so much of information and to know about a person and to understand what are the identify what is it they are looking for. Similarly, when a mediator is having 60 days time, the time limit which a mediator, when a mediation comes, that is a case comes to mediation, we have 60 days time as per the rules. And 60 days, if it has to be extended, even the director or nobody has the control over it. The advocates have to go back to the court to have a memo filed before the court for extension of another 30 days if there is a likelihood of any settlement taking place. It is not to protract the proceedings. It has to be judiciously, discretion has to be used. See, many times parties come here just for sake of dragging, or you will understand with the body language and why they have come, how many references have been made and all that. But if the matter is genuine, if the parties are genuinely interested in to resolve the issues and disputes, they will definitely come out with solutions also. They will be more flexible. They will not stick on to their stance, and they will try to switch over what are the options, workable propositions. Then the matter could reach an amicable settlement. Once the agreement is reached between two parties, that is voluntarily, without any coercion, pressure, undue influence, we all write this in the agreement. And what are the connected matters? Connected matters are also there, and which have to be borne in mind when whatever issues between both the parties have to be identified. Everything has to get into the agreement, and they should be practical and realistic. Suppose it cannot be vague, like the petitioner promises to pay a certain sum of money on certain date and all that. These should be avoided. There should be a crystal clear terms and conditions when a written agreement is drafted. So the mediator has to get into the touch with the advocates, whose role is also very important during the process of mediation. Unless you take the confidence of both the advocates who are present along with the parties, the mediation cannot be always successful. You can always take the active participation. That's what I do in my mediation. I take whoever the advocates present there, I take their role, I sit with them separately also, and I try to identify what is it the parties are looking at and what are the legal strength and weaknesses in the private mediation, and then try to help the parties whatever is possible. So now we saw this. This is called whenever what is the conflict core? What do you understand by this? When we sit with the parties who are in a dispute, there is lot of emotions coming out. Both parties are shouting at each other, and they are for the first time sitting confronting each other. They would not have spoken for many years because there was a dispute between them, and first time when they come to the mediation, they want to vent out their emotional turmoil, and mediator has to be very cool, and he has to be positive. He has to take control of the process. He has to see what is happening. He has to be very actively listening and also watching the body language and take control of the process. And there will be a lot of threats between the parties, and mediator has to understand and reflect upon it with reframing the whatever is told, removing the sting between the parties. Then these are the various issues which I have said. They have to be borne in the mind whenever we have to do the mediation. There will be a lot of threat emerging from disagreements, personal reputation, psychological needs, social background, and all these things have to be borne. See, this is a spiral we call conflict spiral. So right from beginning, it starts with disagreement. It is very simple. Both parties agree and they breach, and it is a breach of contract. Then it goes to this thing. A person equals problem. See, whenever you think person is a problem, then the dispute cannot be resolved. For example, let me give an example of our own children. Suppose a daughter or son, he comes late at home sometime, a college going boy or girl, and what happens if suppose any parent will be offended? They would not have told anything. They will come around 11 o'clock or 10 o'clock, and the parents start shouting. What do you think of yourself? You are just going away. You don't have any responsibility and all this, and they mix up the problem and the person as one. Now, what from the mediator's perspective, what are we supposed to do? I separate the person from problem. I will sit down calmly with my son and ask, why were you late? He will say that I had gone to a hospital. I had taken my friend who had become sick. I had taken him there. I admitted him and I got him treatment, and that is why I could not get the connection because my phone was dead. I could not correspond. See, after listening to the son, then the father will say, oh, sorry, I did not understand that. Instead of shouting and coming to a conclusion, a mediator always has to ask right questions at the beginning, at the threshold, so that he will understand what is the problem and he will separate problem from the person. That is how the mediator separates person from problem, past to the future, and from they will take a definite stance that I want 1 lakh of rupees. If it is a money suit, they will come and say, I will not budge. I want one. They will only harp upon whatever is there that is coming to the court. They think that I will definitely get a decree. What will the mediator do? He will switch over to what is the underlying interest. I understand that recovering the money is your concern. Let us see how it can be worked out. So he will start sitting in the private session and tell the parties that if it goes to court, it will be a lengthy battle. You may or you may not win the case because it is 50-50 in the courts. Whereas in mediation, it is always win-win situation. You can always give up something, you will gain something. If suppose you get the money right now, instead of a long battle, that money can be put in a deposit, it will earn interest, it will become double by the time the litigation gets over. This is how a mediation tries to help the party understand which is better for him, identifying the issues, identifying what is required by the parties, and move on further. So this is how it can be a win-win situation in mediation. So this conflict spiral, if suppose it is not addressed at the right stage, it again escalates into reaction. Most of us, what we do, whenever there is a problem, we normally try to react. What should be done is, there should be a proper response. It is not the reaction which is important. There should be a response from a matured person. As parents or as this thing, we have to understand from the perspective of the children. If we are dealing with the children, if we are dealing with the parties in the mediation, we have to understand what is it they are looking for, what is the need, what is the concern. Let me come to this thing, how the perspective differs. There was an old man who visited a park with two small children, and they come there, and somehow his mind is thinking, and he is not giving his attention to the children who are just moving around in the park and going there and here. And the people who are there sitting along with him, they say, what an irresponsible person he is. He is just sitting there without bothering about the children. And one person goes and very harshly goes and says, what kind of a person you? Don't you think that you have left the children? Why do you come to park bringing the children? You are not even responsible. Then suddenly the elderly person, he says, I'm sorry, did they bother you? See what happened, unfortunately, the father and mother of the children, who are my son and my daughter-in-law, died in a car accident. And after taking the bodies to the burial ground, I am coming directly from the burial ground. These children are, I was just wondering, what should I do with the children, because I have to take care of them. They have nobody else to take care. Suddenly there is a shift, paradigm shift of the mindset. You see, this is the perception. What was the perception earlier? They were thinking what kind of a person, they were trying to blame and all that. What happened when they really heard what was the reality? How did the perception change? From blame to understanding. See, that is why always, without being judgmental, a mediator should never be judgmental. He should not come to a conclusion. He should go to the depth of what has happened. See, each one will have their own problems. Everyone will have their own problems. We have to get into their shoes. We have to be, a mediator has to be more empathetic. Not just lip sympathy will not do. Unless a mediator is empathetic, you cannot understand the perspective of the parties. If you don't understand the perspective of the parties, you cannot move on and help the parties to switch over from the past to present, from blame to understanding, from position to interest. These are the where mediator with their skills, they will try to move the parties, and from there on they will try to generate options and move on towards resolution. And it will end up in both parties agreeing for a mutually acceptable agreement. So when the issues are not identified by the mediator, it cannot be resolved, because he is supposed to be more experienced, and he is neutral, he is impartial without taking sides, and he assures the confidentiality, not only the process confidentiality, but also the caucus confidentiality. Whatever happens in the private caucus is also maintained. When these things are understood by a person without any background of mediation, they will try to cooperate. Let me give you one very old matter where I had sat down. It was very long back. I tried to understand what was the position of the parties. When I sat down in the private caucus, it was a landlord and tenancy case. And the landlord was telling, sir, they have this thing, I had not given them the extension and all that, they have sat down and I want my premises at any cost and I cannot give more time and all that. When I sat down with the tenant, I understood that the landlord had agreed to sell the property to the tenant who was there, and he violated those terms as a repercussion or because of the whatever the breach. The tenant had gone to the extent of forging the document saying that, sir, I extended to another 5 years, the lease is expired. I asked in the private caucus, was it done by you, because the handwriting was different. They in the private caucus said, sir, I should not have done it, but because the owner backed out from his promise and this thing, I did it. So this was the confession which he made. See, these are the things where parties, though they would not have revealed to their advocates, they will tell the mediator. And this confidentiality, I cannot reveal the owner. Then I told the repercussions, if suppose it goes for evidence and you are caught, what will happen? If you have committed fraud and perjury and all that, it will have its own repercussions. Suppose that happens, where will you land? Is it not better to have the matter settled in amicably in the mediation? Then the parties, they had a discussion. They said, I cannot give so much time, I can give a short time. So they agreed for 1 year, and after the 1 year, the owner got their possession and the tenant also could find the alternate accommodation. See, these are the various things where it can be resolved. Everyone would have come with so many different cases where initially it will appear that it will not be resolved, it cannot be resolved, it is impossible. But for a mediator or in mediation, there is nothing called as impossible. I would say that there is always a possibility if any efforts are made. Because unless efforts are made, your efforts can fail, but you should not fail in putting fresh efforts. I would like to give the story of the elephant. An elephant, when it's a small baby elephant, that is calf elephant, its legs are chained. Its legs are chained, it cannot move. It cannot move forward. It thinks that it is imprisoned. I cannot get out of the chain. I am shackled. Even when it grows up, it feels that I cannot, the elephant, you know that how strong it is. It doesn't realize its own strength. Because of its backlog, what is that? Mental block. What had happened in the childhood. It remembers that even when it has grown up, it feels I am still not strong enough to break the chain, and it never makes efforts. So that is the story of even all the human beings also. Even when we can, there is always a mental block that I cannot do it or I cannot achieve. You would have suffered some point of time with some disease or something. You feel that that's the end of it. But no, my friends, I will tell you, everyone will come across some obstruction, some stumbling blocks in their life, even in their daily life or even in the mediation also. I say that there is nothing called, as I told you earlier, there is nothing called as dead end. There is always a bend at the dead end. We can still move on. We have to only look for options. That is what matters. So, I wanted to see, this is what I was telling. Known to others is dispute. It is just hardly 10%. What the courts see is 10%. But when it comes to mediation, what the mediator sees is the 90% which is not seen by the courts. That is the conflict. A dispute may be resolved in the court by a decree or dismissal, which cannot satisfy both the parties. It is one-sided. Again, it is appealable and it goes on and goes on. However, a conflict, though it cannot be resolved fully, but nevertheless, if the conflict is addressed, dispute automatically gets resolved. So the mediator addresses a conflict. Along with the conflict, the dispute always gets resolved. It's a win-win situation. That's why we call. See, dispute also happens because of lack of knowledge. Now, because of lack of knowledge, then lack of information. Proper information will not be there to the parties. They will not be knowing because of their ignorance. They may not be educated, some of them may be illiterate. It may be a language barrier, there may be information, misinformation, and it may also be different interpretation. So everyone sees it from their own perspective. That is how there is a power imbalance. One sided will be very strong, the other sided may be very weak. These are some of the hurdles a mediator comes across. However, a mediator has to see that he balances both sides, maintains the neutrality and impartiality right from beginning till the end. How about the confidentiality, my friends? It is for the younger, the new mediators who have joined. Should the the confidentiality be kept up till the mediation is over or always? Any of you, please? It is throughout our life. Yeah, never. I thank you, Prema Madam. We have to, when we assure the confidentiality, it is forever. I cannot even disclose it with my colleagues, co-mediators or anybody as such. So we will never disclose the parties' names or who it is, but we can just discuss about the gist of it, but never revealing the names. So that confidentiality has all to also be maintained. I want to narrate one very sensitive mediation which happened in my mediation. It was a child, next is the Hakodi. It was a child, it was a child who had come in a custody case, and it was about 5 to 6 years old and very sensitive child. It came inside. I wanted to talk to the child alone, with whom he wants to go and find out what is the child's perspective. So I called him in and I befriended him, asking about the what are you doing and all that. After building the rapport with the child, then I asked him, what is your mother doing? Uncle, it was calling me uncle. Uncle, my mother is a CEO. She goes in the morning and she comes back in the evening, night. She is a very big off. She doesn't have time to talk to me. By the time she comes, I am already asleep. And by the time I get up, she always leaves it to the servant and she goes away. She has no time to give me. How about your dad? Dad is, he takes me to play on the weekends, Saturday, Sunday, though he is busy in the other days, but he has time to spend with me. Then whom do you want to stay or you love more or something, I asked. Dad, he came in the ears, he came closer to me, my ears, because it felt that somebody is listening from the door outside. It was insecure feeling which it had, and sir, uncle, please don't tell this to my mom or dad. I love my dada, though I stay with my mama, because she has no time to talk to me or take me outside. I love my dada because he plays with me. But this, please don't tell my mama because she will become angry. See, this is the confidential information I gathered from the child, innocent child, and I was wondering what a fate or this thing the child is undergoing, such mental agony at this age with so much of insecure this thing. See, the parties, they fight without looking from the child's perspective. Very unfortunate. One child, one parent will be staying somewhere in other place, they have the visitation right, sending the child from this place to the other place by flight, and it has to get down and all these things. So many things, it is all definitely disheartening whatever is happening at the present. It is not desirable. Why is this happening? As mediators, we are social engineers. We have to update ourselves whatever is happening. Though we belong to the older generation where we were giving more values, we all joined mediation because for the values we wanted to do something good for the society. When mediation started in 2007, perhaps I and my other friends here, most of us, we joined because we wanted to give back something to the society. And we had more satisfaction in that. So that was the pro bono we joined, and they said eventually after so many years, they said, no, you are doing so much of good work, we have to give some honorarium. That's how we started, and where we have now. When it started in the beginning, anything which starts in the beginning, there is always resistance. There was a lot of resistance from the advocates bar also. They felt that when once the mediation starts, we may not have much cases. But eventually, when the matters built up and they had more of matters getting settled in mediation, they had more turnover. I see so many of my mediators who are confined only with the family court disputes and all. So many matters come to the mediation that they say that when we go back to the office, we don't have time to sit down. In the night, we have to forcibly close the offices. See, this was what happened. Initially, there was a resistance. After resistance, when they accepted, then they felt that, oh, this is working well. Why did we not have this earlier? See, this is how any person or any change which comes, first initially there will always be a resistance, because there is a tendency among human beings that we don't want to move from the comfort zone. We are always having that mental blocks. We can't go, we can't do whatever we are doing, let me stick on to this. But let me tell you friends, as mediators, we should not have any mental blocks, whether prejudices or bias. If you are interested, we are having some restrictions where we should not take up the cases where we are interested in subject matter, or if one of them is related to us, because there is a conflict of interest. So we are barred from taking that. And if coming to the, yeah, next. So there are some, I will just tell which are the cases suitable and then wind it up. Just another, I will take a few this thing, then we can. So you are all aware that Afghan's Infrastructure Case Limited has given a wide this thing, which are the cases suitable and which are the cases which see, let me just browse it. You are all aware, but just to refresh your memory, and let us browse it. All cases relating to trade, commerce and contracts, including disputes arising out of contracts, money suits, disputes related to specific performance, then suppliers, customers, bankers, customers, then developers and customers. There will be so many projects which are half left. During the mediation process, those half left projects in the mediation which we have done, you know that how it can be resolved. And even in the flats where they are staying, there will be so many issues related to the association. Association, this thing is not paid, maintenance and all that. They all are referred in mediation. Then dispute between landlord and tenants, all wherever there is strain in relationship. Then matrimonial cases, you are all aware, maintenance, then custody of children, then partition, then co-partners, partnerships, firm. And one thing you have to remember when you are dealing with partition suits and all that, and when one person is representing, you have to ask whether he has the proper authority, that is power of attorney, or if it is a company matter, whether the party is having some resolution to conduct the mediation. So these things, unless the mediators are knowledgeable legally, you will not be able to understand. Even if the cases come with wrong provisions, you have to be alert if they are not maintainable, if they are unfit, suppose a nullity of marriage comes, or if there is a declaration of will, it comes before the mediation, or a public interest litigation, we are not supposed to take it up. You have to just say it is unfit for mediation and it has to go back to the courts. And suppose there is an injunction or order required or some direction from the court. So there mediation cannot be done. It has to go back before the court. Or where the original parties are dead and successor or legal heirs have to be brought on record, such type of cases cannot be taken up. And ex parte cases also, my friends, you have to remember that it cannot be taken up unless they can resolve the issues. But ex parte cases cannot be, it has to go back before the court, and if the issues have to be resolved, all the parties have to come before the parties. If the government is only a formal party, you can take it up, but they have to go before the court and say that it is the main parties have settled the matter. That could be resolved. So nuisances and these and tortious liability and sometimes compensation and all that. Consumer disputes also could be resolved, and labor employers and employee can be resolved. They can be referred. Then cases not suitable for ADR. I told you representative suit cannot be resolved because it involves numerous persons. It cannot come before the mediation. It has to be resolved before the court. Dispute relating to election, then cases involving grant of authority, suit for grant of probate of will, it cannot be resolved. Administrative matters, administration has to be, there has to be a court order. Then cases involving serious and specific allegations of fraud, fabrication of documents, forgery, or heinous crimes like murder, rape and all, these cases cannot be come to mediation. And cases involving prosecution of non-compoundable criminal cases, it cannot be resolved. So these are the things which I wanted to share. And there are some limitations. You have to bear it in mind. Sometimes both the parties come with collusive suits, which may not be filed in the court at all. They bring directly something else from out of the blue, and they say that this property also has to be added. So mediator has to be very vigilant, very cautious. Why more than 20 years or 15 years experience is taken? Because those who have been experienced with so many cases, they will be knowing the background, they'll be knowing the legal positions, they'll be knowing up-to-date cases and well versed with the law. Only with this background only the mediators have been selected, so that they should be very vigilant and they could not be misled by the parties. You have to be constantly vigilant, and you cannot say that I did not know or I could not see. Sometimes by oversight also it happens, the courts refer some matters where it would have been filed under different provisions of law, not proper provisions of law would have been incorporated. There you have to send it and have it corrected. So I think I could not exhaustively cover, but whatever was possible within the duration, I have tried to share my thoughts, and any question and answers I would like to ask from my learned mediator friends. Any question and answers, whatever has been dealt, you are welcome. And I also request from the other, that is circuit bench, Gulbarga bench and Dharwad bench, if there are any questions pertaining to the topic which is spoken, any hurdles you have come across where you want to share, let me try to give answer. Any questions, my dear friends? Joe, Ashok Patil, Brinda, anyone wants to ask anything? Can I take it for granted that there are no questions? Lata ma'am, you have any questions? For the betterment, for the better understanding of my other friends, you have anything to ask? If you have left over, you can openly ask me if any topic which needs to be addressed. So,
Thank you, Bharat. You were really wonderful.
okay, I would
covered
say
all
that
40 hours
if you
training.
have any questions, you can put it in the whatever WhatsApp or something. We'll try to find out, and I'll come back to get back on that. I hope that I have justified for whatever has been given during the 1 hour, and I am thankful to the Karnataka Mediation Center and the for giving me this wonderful opportunity to share my thoughts with my learned friends here. It's always learning has no end or beginning. We learn from each one and every constantly, and it should keep going. And because so much technology has coming in and it is developing, now AI is coming in AI, artificial intelligence. So though we are adults, we may learn slowly, but not as fast as the youngsters. But nevertheless, I would say that if the urge to find out some new things are there, we can always learn. With these few words, I once again thank you all, and thank you. Thank you, friends.
Thank you, Bharat sir, for the most positive outlook to mediation. It is, in keeping with the kind of person that you are. You always exude positivity. For the past 17 years that I have known you, I've never ever seen anything but positivity from you, and therefore your entire talk this evening was how if we endeavor today, the fruit will, don't concentrate on the fruit will bear itself sometime. But your endeavor to reach a process and to complete the process should be, unwavering. And there is always light at the end of the tunnel, and there's a silver lining to every cloud, is what I think your talk today showed us. Thank you so much, sir. I would want to ask you a question for another day as to how you keep this positivity going, but that will be a one-to-one talk. Yeah. Thank you so much. Thank you all for being here.